Welcome back to term 2. Basically, I really wish you a happy new year. Let me hope that in this year we are going to really pass the bar. So today I'm going to go through civil litigation term 2 workshop 1, and basically this workshop is going to cover both workshop 1 and workshop 2. So please be with me as I give you my analysis of the workshop. So module 3, we are looking at interlocutory applications and hearing of civil suits. So under this module, we are introducing students to intervention as counsel in an existing suit, interlocutory applications and hearing of civil suits. So basically here, I believe that we were taken through hearing of civil suits in moots. That was in term 1. We at least have an idea, but now we are going to expound on that. Then intervention as counsel. Of course, you can intervene in a matter as counsel after receiving instructions, but also you can intervene when there is notice of change of instructions, assuming that there was some firm representing your client and then you want to intervene in the matter. So there has to be what we call a notice of change of advocates. And then interlocutory applications, we shall be looking at temporary injunction and interim orders, and then the hearing of civil suits. Learning outcomes, by the end of this module, we would be able to explain the process of intervention by counsel in an existing suit, interlocutory application, and during the hearing of civil suits. So you can intervene through receiving instructions, through the change of advocates, and also through amicus curiae. We also looked at amicus curiae, where you can apply to be added in the matter as an amicus or maybe as a friend of court. Then we looked at interlocutory applications. We talked about temporary injunction as well as interim orders. Then present interlocutory applications. So we shall see how do you present interlocutory applications, basically arguing balance of convenience, irreparable damage, maintaining the status quo, basically those grounds which must be proved for you to get a temporary injunction. Then demonstrate case management processes to save court's time and minimize multiplicity of cases. So here we shall look at consolidation of suits, where in case suits are being brought under the same facts and requiring the same remedies, you can consolidate them. But we shall also look at test suits, whereby the court will only try one case, and then if, for example, the defendant is found liable, then the liability will apply equally with other cases. So basically here we shall be looking at consolidation of suits and also test suits. Then we shall also demonstrate case management process to save cost time and minimize multiplicity of suits. Then present civil suits. So basically here we shall go how a civil suit is conducted, from drafting to filing to serving summons to extracting summons for the elections to the joint scheduling conference, to examination and cross-examination and examination of witnesses, to submissions for both parties, and then a ruling. So basically that's how the civil suit is presented. Then 5, recognize and deal with ESCO issues. So we shall look at ESCO issues as far as these facts are concerned. Of course, not overcharging clients, conducting proper due diligence, confidentiality, among others. So workshop 1. The workshop deals with the process of intervention by counsel in an existing suit. Contentious and non-contentious applications made to promote interests of justice and for better case management. Learning outcomes, by the end of the workshop, students should explain the process of intervention by counsel in an existing suit, prosecution of interlocutory applications, and preparation of rulings in respect of the interlocutory application. Illustrate the ability to draft appropriate formal applications, reprise thereto, and submissions. So we shall look at how do you draft submissions for temporary injunctions, as well as how do you reply to them. Then demonstrate case management process to save court's time and minimize multiplicity of suits. We have looked at consolidation of suits as well as test suits. Then issues like the way we discussed above. Then the facts for the workshop, part A. Assume you're a legal assistant at MC Bat and Company Advocates, P.O. Box, Kampala. The morning Mr. Festo Chohirwe is before you and narrates to you the following. His land in Manyagwe is about to be taken by one John Magoba, who has this morning started powering construction materials on the same. He brought several casual workers on site who have started digging a foundation. He instructed MSR&M advocates who filed his case in court, but he feels they are slow and may not prevent Magoba from taking his land. He has handed to you a copy of the plaintiff here to attached and marked an extra A. So we have a copy of the plaintiff which is attached, but then remember now the fact that here he had initially working with other lawyers. Then there must be a notice of change of advocates. So there must be a notice of change of advocates which must be filed to the court through the registrar, and then the court get to know that the client changed advocates. Task A, advise the client on the most appropriate remedy available to him in the circumstances. So basically here, it would be for us to apply for what we call a temporary injunction. And I believe that we have heard about temporary injunctions from our undergraduate. But what you have to understand is that for you to apply for a temporary injunction, there are grounds that must be fulfilled. One, that there is an existing suit, and here we have a plaint. Secondly, that the balance of convenience are in your favor. Thirdly, that there is the likelihood of suffering irreparable damage or injury. And lastly, that there is a need to maintain the status quo. So those are basically the four grounds that you must prove for you to get a temporary injunction. Then what course of action are you going to take in order to effectively protect the client's interest against the roaming eviction from the suit land? So basically here, you apply for what we call an interim order. So basically, once you have a temporary injunction, then you can proceed and apply for an interim order. So this interim order, it's going to be granted to you, and it lasts for a short period of time, but it protects the client whenever there is an imminent danger or certain to harm. So that's when you go for an interim order, or what we call an interim injunction. So draft and necessary documents you would file in court in view of the desired remedy in one above. So when you're applying for temporary injunction, you proceed by chamber summons supported by an affidavit. Then when you're applying for interim order, you proceed by notice of motion supported by an affidavit. Then prepare written statements you would use in court and support the desired remedy. So basically here, if you're going for a temporary injunction, you must prove that there is an existing suit which have been already filed to the balance of convenience are in your favor. 3, there is a likelihood of irreparable damage, and 4, that there is a need to maintain a status quo. So basically those are the grounds you must elaborate on in your written submissions. Then for example, when you are going for interim order, you must prove to court that there is an imminent threat of danger or injury. That's when the court will give you an interim order, because in some instances a temporary injunction may take long, whereas an interim order is always given in the fastest way possible. So basically that's part A. Part B. Assume you are counsel for the defendant after filing written statements of defense, a copy of which is here to attached and marked B. Your client Magoba informs you that apart from the disputed land, the plaintiff has no known property or income in Uganda. In fact, he has been processing a visa to go for Cheyo in United Kingdom. Rumors circulating in the village that he was even planning to sell the land in question so that he leaves the country. Advise the most appropriate remedy in circumstances. So basically here we have to apply for what we call security of costs. And security of costs is where, in case you think that I have no money to pay you as a plaintiff, or maybe I'm an Indian who is most likely going to move out, I do what? I apply for security of costs, so that the court orders the plaintiff to do what? To pay a specific sum of money into court. In case he or she loses, then you don't go to execute, you only attach that money which has been deposited in the bank. So that's what we call security of costs. And we shall see security of costs in the High Court, further security of costs in the Court of Appeal, and further security of costs in the Supreme Court. So, but basically here we are looking at the High Court, so we shall only apply for security of costs, and the necessary documents would be chamber summons supported by an affidavit. But you have to look at the civil procedure rules because they provide you for the documents. That's where I get these documents from. So don't take my word the way it is. First go and verify from the civil procedure rules on whether the order provides the necessary document. But if it does not, that means we shall proceed by notice of motion. But here in security for costs, we proceed by chamber summons. Then part C, assume that as counsel for the plaintiff, you secured order in part A above, the defendant has continued to steal the land, cut down some trees, and he's still bring materials on the land. Task C, advise the client the most appropriate remedy available to him in the circumstances. So basically here we are looking at contempt of court, like they have recently seen in the federal court martial, but basically here we are looking at contempt of court. And those necessary documents you would file in court in view of the desired remedies. I think proceed by notice of motion supported by an affidavit for you to get contempt of court, but we shall have to verify that. Then written submissions for you to get contempt of court. You have to prove that you have to prove that you served the plaintiff. You served the plaintiff with the order. Secondly, the plaintiff or the defendant has refused to abide by the order and has continued to do what the order was restricting him to do. Basically, that's what you prove for contempt of court. If you are served with an order and you don't comply with it, then they can go for what we call contempt of court in case you fail to comply with the court order, like the way we saw in the court martial. But I don't know whether the ingredients were properly achieved. But that's what we are looking at as contempt of court. Then we are going to part D. Following the accident that occurred on 20th October 2023 involving Isuzu truck registration number UAT belonging to Kabiswa Godfrey being driven by Boy James mentioned in Module 2, several persons were injured, to wit Johnson Beyanga, a border rider, Lydia Nakatude, a passenger on the border, and Mabati Godfrey, Chaco dealer at Mpigi police stage. All the time filed separate suits in Mpigi Chief Magistrate's Court seeking in for special damages. So advise your client on the course of action. So basically here we shall look at consolidation of suits and how we go about consolidating suits. And the document for consolidation of suits is a notice of motion. It's a notice of motion supported by an affidavit. That's when you can go for what we call that's when you can go and consolidate all these suits. You proceed by a notice of motion supported by an affidavit when you're going for consolidation of suits. So also you have to address your mind to what we call test suits. Because consolidation of suits is always taught with test suits, but consolidation of suits arises where the facts are arising from the same, where you have the brief facts arising from the same facts, and the parties are seeking for the same remedy, like the way we saw, in the accident. So basically, for consolidation of suits, you proceed by summons in chambers under Order 11, Rule 2 of the Civil Procedure Rules. So consolidation of suits, you proceed by summons in chambers. Then test suits is where you proceed by a notice of motion supported by an affidavit. So you have to clarify that test suit is is where now the court wants to use only one case to try the liability of the defendant. In consolidation is where the court is bringing out all those claims, for example, in the accident brought about the same defendant. In consolidation, you proceed by chamber summons, whereas in test suits, you proceed by a notice of motion. Then we are going to, I think that was it for workshop 1. Please, we have a mentorship group. In case you want to get well-researched notes, you want a discussion, because we always conduct an online discussion on Saturday and also on Sunday. So we cover both campuses, because all our discussions are online, and also we get to meet your committed students from different campuses where they give you different opinions from their PAs. So please, in case you want to be part of that group, you can WhatsApp me on the number on this YouTube, and then it's a payment of an affordable investment or subscription fee monthly, and then you'll have to benefit from that group. But in case you can't afford, I understand that, then this guidance coupled with a discussion from your PAs and your students can still lead you to the promised land. But also, if you want to save time and money is not one of your problems, please come and you get to meet other committed students in that group. So part D, we have looked at part D, basically where we discuss consolidation of suits and test suits. Then part C was about assume that as counsel for the plaintiff issued orders in part B above, the defendant has concluded it was contempt of court. It was contempt of court. Whereby we said contempt of court, you proceed, I think, by notes of motion. Proceed by notes of motion, if I'm not mistaken. So let us go to workshop 2. Let us go to workshop 2, and then for workshop 2, we shall be dealing with the workshop is on procedure and skills of handling objections and conducting an effective hearing of a civil suit. SAS, it covers weeks learning outcomes on the ability of students to conduct an effective learning and ISCO issues. So learning outcomes, by the end of the workshop, students will be able to 1. Explain how to present a civil suit for hearing in court, illustrate how to present a civil suit for hearing, demonstrate how objections are raised during the hearing of the civil suit, recognize and deal with ISCO issues. So part A, assuming that pleadings under workshop 1 have been closed and all the interrogatory applications therein have been determined. Subsequently, both counsel were directed by the registrar to prepare and file their respective trial bundles together with the joint scheduling memorandum. However, both counsel have failed to agree on the issues for determination. Task A, prepare and file a joint scheduling memorandum, trial bundles, and witness statements of the plaintiff and defendant key witnesses respectively. So I'm sure that you understand the contents of the trial bundles. Basically, the trial bundles contains brief facts. It contained agreed facts. It contained disagreed facts. It contains the list of documents that is supposed to be relied on by both the defendants and the plaintiff, the list of witnesses, the list of authorities that are going to be relied on. So it also have witness statements of both the witnesses of the plaintiff, as well as witness statements of the witnesses of the defendant. So basically, that's what we have in a trial bundle, and it's always a joint scheduling memorandum. It's what happens after the extraction of summons for the elections. Then you go to a joint scheduling memorandum, which always appears before the judge who is going to try the matter. So basically, he wants to guide you on how fast can this matter be disposed of. So we have looked at the joint scheduling memorandum, we have looked at trial bundles, witness statements, and the defendant's key witnesses, which is all. I believe that through the moot, we managed to meet all these things on how to prepare trial bundles, because I believe that we looked at them in term 1, basically when we are dealing with moots. So Part A, by way of a legal opinion, illustrate how issues are framed and the burden of proof and standard of proof in the civil suits. So we have an order which basically governs framing of issues, and it's important to note that framing issues is the power of lawyers, but also the courts can also participate in what? In the framing of issues. It's both the role of both counsel as well as court to properly frame the issues before court. So the burden of proof, of course, in the Evidence Act, Section 101 of the Evidence Act, is to the effect that he who alleges must prove. So basically that means that the plaintiff always have the burden of proof, but the standard of proof is always on the balance of probability. It's not beyond reasonable doubt like the way we saw in criminal cases. So framing of suits is under Order 15, which basically talks about settlement of issues and termination of suit on issues of law or on issues of agreed upon. Then Order 15, Rule 1 talks about framing of issues. So basically you have to read that order on framing of issues. Then Part B, assume you are counsel for the plaintiff, advise on the causes of action you would take on the following scenarios. It has come to knowledge that the judicial officer handling the suit in workshop 1 was a classmate and actually roommate in the counsel for the defendant while they were perusing their undergraduate and postgraduate studies at LDC. So basically here you apply for what we call recusal of judicial officers. In case you think that there is going to be bias, you apply for recusal of a judicial officer. And we have the case of, I think, Mari Mabirizi, which basically discusses how do you apply for recusal of a judicial officer in instances where you think that the judge is going to not properly render justice. Because what you have to understand is that in recusal, also in suits, the judge must be neutral. So where he is not neutral, you can apply for what we call recusal of the judicial officers. But in most instances, they can recuse themselves if they think that there's going to be conflict of interest. And I think the recent election petition, whereby they were applying for recusal of Chief Justice, it also discussed that. But we have the recusal of judicial officers in the elections, which we shall also look at. Then 2, you had closed your client's case prematurely before tendering in the purchase agreement with Amos Matovu, Moses Sebowa, and Henry Chintu. However, the suit before the court today is for hearing of defendant cases. So basically here you apply for what we call reopening of the case. So as when you reopen the case, you can now the court can now hear you tendering in this sales agreement which you had refused to do which you had forgotten to tender in, but you must prove to court that it is in the interest of the case that the case be reopened, so as you can tender in the sales agreement. So the process is called reopening the case. Then third, assume that you are the judicial officer hearing the case and you grant the plaintiff's prayer in 2 above. However, on the day scheduled to tender in the agreements in court, neither the plaintiff nor counsel for the plaintiff were in court. What steps would you take in the circumstances? So basically here, if I was a judicial officer, I would adjourn the matter on a specified date so as counsel can be available and they make the necessary submissions, because if it being the first time, I wouldn't just dismiss the suit. So basically what I would do is apply for adjourn the matter under Order 17 of the Civil Procedure Rules. Then 4, Both parties are in court and the suit has come for defense hearing for the third time, but the same has failed to take off. The defendants are not willing to proceed, citing flimsy reasons. So basically here now I would dismiss the matter. Because now it seems that the plaintiffs do not have a good case because they are delaying the justice. So I would dismiss the matter on the ground that the plaintiff is not taking reasonable steps to litigate his matter. So I would, here at this stage, I would dismiss it. Then another one, the defense counsel has just completed examination their last witnesses, and the court desires to know from you on how to proceed next before judgment. So basically, what happens is the plaintiff begins with its witnesses. Then after the plaintiff is done with its witnesses, the defense counsel cross-examines those witnesses. Then after cross-examination, we have what we call examination in chief. Then after that, we go to the defense counsel, who also examines in chief his witnesses. After that, they are cross-examined by the defendant and then re-examined by the defendant. They are cross-examined by the plaintiff and re-examined by the defendant. Then after that, what we have is submissions from both parties. The plaintiff makes his submissions and the defendant makes his reply as well. Then after that, the court makes a ruling according to the deliberations of both counsel for the plaintiff as well as counsel for the defendant. So basically that's what follows next. Then we go to look for workshop 3. We shall be looking at the moot. Remember now, moot is going to be marked. So it's really very important that you pay attention to the moot, because also the IA, which is going to be marked as well, it can also come from the moot documents or the moot procedure. So you have to pay attention to the moot and don't undermine it, thinking that it's only work for counsel for the week, because a question can come from it. So we are saying that the workshop deals with the process of intervention by counsel in an existing suit, contentious and non-contentious applications made to promote interests of justice. The facts in workshop 1, task A, will be applied so as to prosecute the main interlocutory application. So basically here we are looking at the main interlocutory application, which is a temporary injunction. So learning outcomes: by the end of the workshop, students should be explain the process of intervention by counsel in an existing suit. Of course, you must file what we call notice of change of advocates. Then prosecution of interlocutory applications. Since we are prosecuting main temporary interlocutory application, which is a temporary injunction here in this case, you have to deliberate on those grounds, basically that there is a main suit, secondly, balance of conveniences in your favor, third, likelihood of irreparable damage or injury, and also needed to maintain the status quo. So basically those are the grounds you submit on in your submissions. It has further ability to draft appropriate form applications, replies thereto, and submissions, develop ability to demonstrate the prosecution and termination of interlocutory applications, and recognize ESCO issues. So basically I think we looked at basically the ESCO issues, like from how we discussed from the professional advocates test. So I think that's it for today. That's our analysis of civil litigation week 1 term 2. Please endeavor to understand the principles like the way I have given them to you, and then look at the civil procedure rules to verify the necessary documents. I'm also going to take some time to look at the civil procedure rules and I see whether the documents I gave you are the right ones. But please, where you are not comfortable with the document, just take the CPR, because the CPR provides you for the mode of procedure. So we shall also have another video on family family workshop for those the general intake. Please, as soon as your workshop is out, then we shall release the video to help you in your preparation and gives you where to begin from. But term 2 is really very easy, irrespective of the fact that we shall be having marked IAs as well as oral exams. But term 1 was very hard in the content we covered and also the complexity. If you can see in this workshop, you see things are not hard, they are simple and straightforward. So I really wish you a happy new year. Blessed are those who believe what they cannot see. I believe that you have faith that you're going to pass the bar course because faith can move mountains. So we remain the Pass Bar team. Please subscribe, like, share, and comment. So as we can continuously help you or as we simplify the bar course. But also in case you have a larger budget, you can consider joining our mentorship program as you help us as we help you. So please have a blessed day. We wish you success from the Pass the Bar team.